Hey y'all, it's Paul Davis, the fired up Texas lawyer and the lawyer for Patriots. And like you, I am outraged that the Sixth Circuit Court of Appeals has reinstated Joe Biden's completely unconstitutional OSHA vaccine mandate. I can't, for the life of me, fathom how a U.S. Court of Appeals could possibly think this is constitutional. If you don't know anything about me, I've been practicing employment law for over 10 years. I worked for large international law firms for years defending employers. I was later hired as in-house legal counsel and human resources director at a large national insurance brokerage. But I was fired from that job for peacefully and lawfully exercising my First Amendment right to protest against election fraud outside the U.S. Capitol. So I know what it's like to be faced with losing your job for standing up for what you believe. I was crucified by the left-wing media. I was demonized by the radical left mob, but I fully believe that God allowed all of that to happen so that I could start my own law firm to help God-fearing patriots like you who refuse to bow down to the vaccine mandates get religious exemptions and to fight for you if your exemption's been denied. My 10 plus years of employment law experience has taught me all the tricks employers use when it comes to discriminating against employees, and now I'm going to teach that knowledge to you. If you didn't know, I host a weekly online workshop where I teach you everything you need to know about applying for religious exemptions and what to do if your exemption has been denied. Because I know a lot of you are scared right now and you need help, I'm actually giving you my latest workshop presentation for free on my new YouTube and Rumble channels, and that's going to be Fired Up TX Lawyer on YouTube and Rumble. I'm also launching a new website in the next week that's going to give you access to templates that you can use that I've created to give you the best chance to get your religious exemption approved or to get a denied religious exemption reversed, and you'll get access to live instruction on how to use those templates, and you'll have access to an unlimited Q&A session to get all of your questions answered. And that website's going to be www.vaxexemptions.com. That's VAXX exemptions.com. So keep checking that URL, should be up in the next week. In the meantime, you can get all of that material and more by emailing my assistant at admin@fireduptxlawyer.com. That's ADMIN@fireduptxlawyer.com. And I hope you find my free presentation helpful. Thanks. The video you're about to watch is the slideshow presentation of my online workshop. So if you want access to those other materials I just mentioned, again, just go to the website once it's up, or in the meantime, email my assistant. And you can also follow me on Instagram and Facebook at FiredUpTXLawyer. I post a lot of information there, and I try my best to respond to DMs and comments, but I get a lot, so I can only do so much. But anyway, again, I hope this is helpful, and thank you for watching. So, thanks for joining. And just a little background on me before we begin. I went to University of Texas School of Law 2011, worked for a couple different large international law firms, first in Houston and in Frisco, where I live now. And then I was hired by one of our clients, Goosehead Insurance, to be our in-house counsel and HR director. And then I, like I'm sure a few of you, was disturbed by the lack of integrity I observed in the 2020 election and decided to exercise my First Amendment right to go protest outside the U.S. Capitol. I did not go inside. I didn't do anything illegal, just stood outside and protested. And I was gassed, tear gassed, and decided to make a video about it. And some journalist for Salon.com ripped my Instagram story, made it go viral, and got me fired the next day after 1.7 million people saw the tweet by the next morning. And so I started this law firm to help patriots and like-minded people fight for their rights and for America First causes. And it's just amazing that God put me in this situation, because I do have a pretty extensive background in employment law. I've been doing this for about 10 years, so I know everything about how to apply for religious exemptions and medical exemptions. And just for fun, this is the tweet. This is the moment I saw it, when it had about almost 500,000 views when I got back to my hotel room. And then the next morning, Goose had pinned this tweet and kept it pinned for about a week. So that was fun. Got a nice little visit from the FBI and told them to go pound sand because I didn't do anything wrong, and haven't heard from them since, thankfully. But so the applicable laws here are going to be, and this is whatever state you live in, Title VII protects you. And that's the statute that prohibits employers from discriminating against you on the basis of religion, race, sex, color, and national origin. Here we're going to focus on religion because most of you are probably applying for a religious exemption, or maybe your religious exemption's been denied. And by the way, if you have questions throughout the presentation, go ahead and put your question in the chat, and then I will address all questions at the end of the presentation. So if you're applying for a medical exemption, that's the Americans with Disabilities Act. That also applies in all 50 states. It's a federal law. If you live in Texas, we have Texas Labor Code Chapter 21, which mirrors federal law in prohibiting employers from discriminating against you. And your state likely has a similar law to Texas. Most states do, but I'm not licensed in any other state than Texas, so I can't comment on any other state's law. But I can tell you 100% for sure that the federal laws, Title VII and the ADA, protect you. It is sufficient, and so you should be good whichever state you live in. So your employer is required to provide a reasonable accommodation for your sincerely held belief or your medical disability. And I want to address this because there's a lot of confusion on to what extent the U.S. Constitution automatically protects you from employer vaccine mandates. And unfortunately, I hear a lot of people saying things like, well, the Constitution protects me from my employer's vaccine mandate, and I'm not required to apply for a religious or a medical exemption because of the U.S. because of my constitutional rights. And while I think the spirit of the U.S. Constitution would definitely be against any kind of employer vaccine mandate, unfortunately, does not. The Bill of Rights was adopted by our founding fathers to protect you from the federal government infringing on your individual rights. It didn't even protect you from your state government infringing on your rights until the passage of the 14th Amendment after the Civil War. That's the amendment that extended the Bill of Rights to protect you against your state government. So, little known fact, your state could ban a certain religion up to the passage of the 14th Amendment, and the Constitution really had nothing to say about it. And that's because the framers really envisioned our republic as a federalist system where states have broad authority, and it's a weaker federal government. But obviously we're a long way from that point in time because our federal government's gotten out of control. And so, it's kind of easy. It's easy to understand this concept because, probably some of your employers may ban firearms in the workplace, or they may say, well, we can randomly search your things and, to see if you have contraband on our property, or we can ban you for saying certain things in public. And, they can do that because it's not, again, the Constitution doesn't apply, the Bill of Rights doesn't apply to private employers. It protects you against the government. So it's actually up to if you live in a state, I think the only state that's passed a ban on vaccine mandates is Florida. I could be wrong about that, but I think Florida is the only state. So you should definitely call your state representatives and ask them to put, legislation to ban employer vaccine mandates on their agenda. And just so you understand what's going on with these federal cases, and this is kind of before we get into just the practical aspects of applying for exemptions. So the reason that the federal vaccine mandates are being struck down by the courts as unconstitutional is because only Congress has the authority under the U.S. Constitution to create laws. So what's going on here is Biden is using laws such as the OSHA Act, which has really nothing to do with imposing a vaccine mandate, and saying that he has authority to impose a vaccine mandate. Well, that's not what Congress gave him the authority to do. So that's why this is being struck down as unconstitutional, because basically Biden is creating his own laws outside of the legislative process, if that makes sense. So status of, I need to update this slide. Actually, as of today, unfortunately, the CMS mandate, which was blocked nationwide by a Louisiana federal judge, the Fifth Circuit, a 3-judge panel on the Fifth Circuit Court of Appeals today, consisting of, it was like 2 Obama appointees and 1 Bush appointee, lifted this injunction. And so now 26 states, including Texas, are under the CMS mandate again. So I'm hopeful that the next step would be asking that this was only a 3-judge panel on the Fifth Circuit, which is usually how appellate courts work. But then you can file a motion for an en banc review, which would be the entire Fifth Circuit. So I'm hopeful that the entire Fifth Circuit will review this and put the nationwide ban back in place. Otherwise, it's going to have to go up to the Supreme Court. So the OSHA mandate, still there's an injunction in force that will last till trial. Only the Sixth Circuit, which has that case now, has the power to lift it. It looks like they're not going to, so that might go up to the Supreme Court. A lot of people are asking me, and the federal contractor mandate is banned nationwide as well. A few people have asked me, well, the Supreme Court just ruled that the New York law, the New York vaccine mandate is, they're going to uphold that. Like the Fifth Circuit refused to, the Supreme Court refused to take that case. And I think that's just because, I don't agree with the decision, but I think that it's because traditionally states have actually pretty wide, broad authority to impose things like vaccine mandate under their individual state law. And that, again, goes back to the concept that we're supposed to be a federalist system where states have broad authority to create their own laws. So anything that's not prohibited by the Constitution, states can do. So I don't think that, ruling by the Supreme Court is going to negatively affect the other mandates, is not an indication that the court's going to overturn the other, lower court decisions on the mandates. So applying for an exemption, only two things are required. One of them would be to send this lovely graphic to your employer. Kidding, obviously, but so you want to describe, all that's required is to describe the nature of your sincerely held belief or your medical condition and just state what accommodations you're requesting. Now, there's a little bit of confusion on, some people call it, what's the difference between an exemption and an accommodation? So under these laws, when you have a medical condition or a religious view, religious conviction that is in conflict with an employer, one of your employer's policies, then they are required to, you request an accommodation. That's what you're requesting. And so here, exemption and accommodation are kind of interchangeable terms because the accommodation that you're requesting is to be exempt from the vaccine mandate, if that makes sense. So exemption, accommodation, it pretty much means the same thing in this context. So medical exemptions, this is actually, if you can qualify for a medical exemption, this is a better exemption to get because it's more difficult for the employer to deny it because with regard to religious exemptions, the employer can deny it by showing that it imposes more than a de minimis cost. And I'll go into that in more detail, but that's not the case with medical exemptions. The employer has to show that it places a substantial burden on the employer to accommodate your medical condition. Now, the harder thing, I think, probably many of you already know this or have found this to be true. It's really, really hard to get a medical exemption from the COVID-19 vaccine mandates because it's really hard to find a doctor that will sign off on it. And that's because these doctors are being threatened by their medical boards with losing their license. And it's completely ridiculous. A doctor sent me a letter today showing what their medical board said with regard, basically said, if you spread any disinformation about COVID-19, which would probably include saying that you should be exempt, they could lose their license. So it's really shocking. And I'm looking at trying to bring a lawsuit against some of these medical boards in discussions with folks about that. So that's the medical exemption. You don't really need an attorney to help you apply for a medical exemption. It's more between you and your doctor. So all you have to do is just tell your employer that you have a medical condition that puts you at risk for receiving the vaccine, and then they will give you a form to give to your doctor. And so that's kind of how that works. It's between you and your doctor and your employer. Now, an attorney would be helpful if your medical exemption is denied, and then you can have an attorney review that. But as far as just applying for it, probably don't need a lawyer. I mean, I'm not telling you not to hire a lawyer, but it's more between you and your doctor. And I guess I should say too, just a general disclaimer, giving you this information, these forms, does not create an attorney-client relationship between us, and you should not take this as legal advice. You should consult your own attorney. So just have to say that for ethical reasons. So religious exemptions, typically we see three different beliefs, three different bases for applying for religious exemption. That's, aborted fetal stem cells, bodies, temple, Holy Spirit, and the mark of the beast conviction. And so these are aborted fetal stem cells, pretty easy to understand. I'm sure you all know by now, all of the COVID-19 vaccines were developed using aborted fetal stem cell lines. The only complication with this, asserting this as the basis for your sincerely held belief, is that a lot of some employers, I wouldn't say a lot, but some employers will give you a form that has a whole laundry list of products that were also developed using aborted fetal stem cells, and they want you to commit to avoiding all of those other products. And you don't have to take the employer's word for it. Here's a link if you want to maybe take a screenshot or something that you can go to that has a list of the products that were actually developed using aborted fetal stem cells. A lot of some employers I've seen will say, oh, we need you to commit to avoiding Tylenol, Advil, Motrin, Pepto-Bismol, and these other, medications that most of us take. And the truth is there was some third-party testing performed on those products using aborted fetal stem cells, but it does not appear that they were actually developed using aborted fetal stem cells. So you can make that distinction. And if your employer asks you about it, says, are you committed to not using this product? Then you can say, well, I will look into that. And if I find out that it was developed using aborted fetal stem cells, I will avoid that. And I'm committed to avoiding all such products, but I'm not just going to take your word for it. I've seen, one of my clients, they had that form, and I just had them, we used just a PDF tool just to put a statement in there saying, I do not agree that these products were developed using aborted fetal stem cells, and kind of made that whole description. So that's how you would handle that. All right, body is a temple of the Holy Spirit. This is something that, some people are a little uncomfortable with this argument because you're basically saying that a lot of my clients are concerned about getting into an argument about the science of the vaccines with their employer, because what you're saying here with the body of the temple of the Holy Spirit conviction is that I, as a Christian, have a responsibility to honor God with my body, which means taking good care of it. And that means that I don't receive a medical intervention where it appears that the risks outweigh the benefits. And so, of course, that requires that you, and I'll show you what I've done in my letter later, that you show your employer, I've looked at this and there are some very, very severe risks to this vaccine. The vaccine does not even prevent transmission of COVID-19. So therefore, I can't in good conscience put this in my body because it would be irresponsible and it would not be honoring God with my body. And actually, if you're Catholic, this is straight out of the Catechism. It's known as the doctrine of therapeutic proportionality. Lots of Protestant, it doesn't matter whether you're Catholic or Protestant. You can use this argument. I'm just saying that this is what it's technically called in Catholic theology. So, and then the mark of the beast, not as many people use this one, but it does work. It's perfectly fine as a basis for objecting to the vaccine. And, it's just the concept that the mark of the beast is described in Revelation, states that you have to receive a mark in order to buy or sell anything. And so the fact that you have to receive a vaccine in order to work and get paid is kind of moving us toward that system. So some Christians will say, I can't support this because I'm supporting this mark of the beast, this move towards a mark of the beast system. And that does, there's nothing wrong with raising that. Now, employer's response. Once you apply for a religious or a medical exemption, this starts what we call in employment law the interactive process. Your employer is required to look at everything that you've submitted, and I say everything that you've submitted because a lot of your employers, and we'll talk about forms in a minute, have given you a form, and they want you to fill in all their little boxes, and they're kind of acting like this is the only way you can submit a religious exemption. And you definitely should submit your employer's form, but you're not limited just to that. So the best practice that I encourage all of my clients to do, and we've had a lot of success on vaccine mandates. I think we're up to around close to 150 clients and gotten about a little over a third of those granted. Technically only 3 denied now, because I had 3 clients that had their exemptions denied. They were all healthcare workers, which, that's kind of the most hardcore employer as far as vaccine mandates. But I did get one of them reinstated by sending a demand letter. So we've only really had 3 denied out of our 150 clients. The rest of a lot of employers are still just sitting on it because they're waiting to see how everything plays out in the courts. But I think that because I don't think we're going to see the return of the OSHA or the federal contractor mandate just because of the courts that those are going through. And so I think that I think those are going to get granted, the ones that we're waiting on. So an employer can only deny your request for religious exemption from the vaccine mandate if they have to either show that your belief's not sincerely held or that it presents an undue burden, which is more than a de minimis cost. And so I'm going to go into a little more detail on what that means. Your sincerely held belief, it is next to impossible to deny your religious exemption on the basis that your belief is not sincerely held. Your employer is going to have something fairly significant, fairly clear and convincing that you really don't believe what you believe, because your belief is personal to you. The EEOC guidelines, and these are quotes from the actual Equal Opportunity Employment Commission's guidelines, which are developed from federal case law, which is what federal courts, the opinions that federal courts give and the holdings that federal courts give. And a belief, it's really personal. You can even be, a lot of people are afraid that, they're like, oh, I'm a Catholic and the Pope said that, encourage us all to get the vaccine. And they think that they can't get an exemption because of that. Or, if you're Mormon, the president of the Mormon church has said the same thing. And, a lot of evangelical pastors have encouraged people to get the vaccine. I've seen employers put that in their forms. This pastor has said you should get the vaccine. And guess what? No pastor of any church that you belong to has the right to tell you what your personal belief is with regard to the COVID-19 vaccines when it comes to religious exemption. You can be literally the only person on the entire face of the earth that holds your individual belief, and that is still acceptable under Title VII. And, I want to mention too, even if you're not religious, you can technically still get a religious exemption. So, share that with your friends if they're atheists, but they just have a moral conviction against getting the vaccine, as long as it occupies a place in their life. This is that quote, parallel to that filled by God. So it's a strong moral conviction. You can still get a religious exemption, even if you're not actually religious. Little known fact. And then this is why it's hard to deny the sincerity of your belief. The employer is required to assume that your belief is sincere. And, a lot of employer forms say, please submit a letter from your pastor or another clergy member that supports your belief. And they're actually not allowed by law to require that from you unless they can show that there's some objective reason to question the sincerity of your belief. And, they'd have to have some kind of evidence that shows a pretty significant inconsistency between your belief and your actual, the way you live your life. So, you say you're a Christian, but they have you on video attending the Church of Satan, and even then you could say, well, I was going there to pray against what they're doing. How are they going to prove that your personal belief is not sincere? Now, one question I get is on this topic is, well, I'm a smoker and, I'm asserting attempt the Holy Spirit. Is that a problem? I would say, most employers I haven't seen a single employer ask about that type of situation, but, you would just need to kind of come up with your own conviction about why it's okay for you to put something else in your body, but it's not okay for you to take the COVID-19 vaccine. And again, it's your personal conviction. So however you want to describe that, it should be fine. And the employer can't really second guess that. Now, just getting to some common questions we see on, and probably some of these questions are on the forms that your employer has given you. Pretty standard, what's your sincerely held belief? You're just going to want to say Christian. You don't really need to say more than that. Or if you're another religion, put that. And then, describe the nature of your belief. That's where you describe, I know that all the COVID-19 vaccines were developed using aborted fetal stem cells, put that. I'm going to get to that more in specific on, or specifically when I go through the actual materials that I've given you. And then this one is pretty common. Does your belief prevent you from receiving other vaccines or just the COVID-19 vaccine? It's going to look a lot stronger if your belief, if you have a general belief, like like, take the aborted fetal stem cell thing. You have a belief that you're not going to get your conviction prevents you from getting any vaccine that was developed using aborted fetal stem cells. So that's what you're going to say. I'm not getting the COVID vaccine because of this, but this also applies to other vaccines. And, they're going to want to, a lot of them ask, have you received other vaccines in the past? And people are I think that's the most intimidating question for people, because they're scared that it's like a gotcha question. And, the way to get around that is just, most of my clients did not realize that aborted fetal stem cells were used in vaccines until they researched the COVID-19 vaccine. So the fact that you've gotten other vaccines in the past that were developed using that's not a problem, as long as you say, well, now that I'm aware of the issue, moving forward from this point in time, I'm not going to get vaccines that were developed in that way. Or in this question, are there other aspects of your sincerely held belief related to medical care? That would be kind of the general. I tell my clients, if they get that question, that's where you're going to want to put the general. I don't receive medical procedures or interventions where the risks outweigh the benefits. So that applies to all medical care. And I don't receive any pharmaceuticals or vaccines that were developed using aborted fetal stem cells. And then, we covered, are you able to provide a letter from the clergy? You can just put, if you get that specific question, just put, I'm not required by the law to provide a letter from a clergy member. And if you want that, you're going to have to tell me an objective reason to question the sincerity of my belief. And I'm going to have to discuss that with my attorney. How long have you held your belief? That's just, that's kind of trying to get at, like you might be might be trying to say like, oh, I've held this belief for 5 years, but then they're like, oh wait, you got this vaccine within that 5-year window. But so that's why you want to put, I've always held this belief about aborted fetal stem cells, but I just became aware of this issue. It's really not that complicated. I had to give you some comfort. Out of all my clients, I have not had a single employer try to deny a religious exemption based on the fact that there was an insincere belief, because it's just really hard to do. This is a question I see on a few forums. Did you download a template or a sample provided by a third party? I've seen it on like American Airlines and a couple others, and they're really just trying to look for some reason to flag you and review it further. But it's really not a legal basis to deny your exemption request. So don't be intimidated by that question. But at the same time, if you're using a sample like the ones that I'm giving you, it is best to try to put it in your own words as much as possible. But again, it's not, if you just use a form, as long as it reflects your personal belief, that really shouldn't be a basis for denying your exemption. That's not a legal basis. So just so you know on that. And then in my forms, I put, I've consulted an attorney, which you have consulted an attorney. Again, I'm not your personal attorney, but you did consult an attorney. So that'll kind of let the employer know that an attorney helped you prepare this and your rights. We covered that. Let's see. This is just, some of these questions are they're just harassing. They don't really do anything one way or the other. Like, do you attend services? Does your religion have holidays? Like, you can just answer those honestly. They don't really matter one way or the other, in my opinion. This one, I've seen this on Southwest. This one was on Southwest Airlines form. Does your religion have a hierarchy of leadership? And we put, well, the Bible says that Jesus Christ is the head of the church. So, Jesus Christ, that's the hierarchy of leadership, and that exemption got granted. So that's just to show these questions they're just harassing. This one I saw, this was also on Southwest Airlines, total gotcha question. They're trying to look, just so you can have more than a religious reason for not getting the vaccine mandate or not getting the vaccine, and that doesn't negate your entitlement to a religious exemption. But if you see this, just check religious, and that'll avoid issues. I see this. Sign below to acknowledge that by being vaccinated, you present a safety risk to those around you. A lot of employer forms have stuff. Oh, sign this to acknowledge all these statements. Well, if there's something on there you don't agree with, the way to handle that, a lot of employers require you to check the box and submit the form. You can't even submit it unless you acknowledge. So you can if there's a text box, or if you want to use like a PDF tool to put in there, I don't acknowledge, I had to sign this to submit the form. I had to check this box to submit the form, but I don't agree with this statement. I don't agree that I present a safety risk to those around me any more than a vaccinated person, because again, the COVID-19 vaccines do not prevent transmission of COVID-19, as we'll see here in a little bit. So talked about, it's much easier if an employer denies a religious exemption. It's almost always because they're going to say there's an undue burden. Now, if you have the ability to work remotely, especially if you have been already working remotely, then your employer does not really have a leg to stand on legally if they try to deny your religious exemption, because they've already shown that you can work remotely by allowing you to do it. And so they've shown that is a reasonable accommodation. That's something that they allowed during the pandemic, or maybe you were hired as a work remote employee. But if you can do that, that's a pretty slam dunk, oh shoot, sorry. Let me go back here. Just talking about this slide. Oh, geez. That's the only problem with using the Google slides. It tends to do this. Bear with me here. Okay, let's see, where were we? It's really held. Form questions, undue burden. Okay. So, yeah, the undue burden, and so like if you are able to work remotely, that's pretty much a slam dunk. You're almost certainly entitled to an exemption. Some people are in a situation where they mostly work remote, but then they have to go meet with clients in person or go to like a conference or something like that. And you can, if you're in that situation, you can request video conferencing as an accommodation. You can request, if there are times where you absolutely have to go into the office and have to be around people, you can request testing, submitting a negative test as an accommodation, and that shouldn't be a problem. And then if you can't work remotely, I'll show you in the letter, we're just going to educate your employer on the fact that this vaccine doesn't prevent transmission. So there's really no burden on them, because the burden they're going to say is that you are a risk to those around you. That's what they're relying on in almost every situation that I've seen. And so we're just going to show your employer that is completely false. And guess what? If you deny the exemption on that basis and this goes to court, you're the one that's going to have to prove that I was an undue burden. So you're going to have to put on a doctor that says, these vaccines prevent transmission. They're going to have to go through the medical studies. But unfortunately, the CDC director herself has actually admitted that the vaccines don't prevent transmission of Delta or Omicron. And so, they don't really have a leg to stand legally there. Now, testing and masking as accommodations, a lot of people, obviously, we don't want to wear a mask at work, and it is unhealthy. And there are studies on that, actually. And so if you want to request a religious accommodation from getting masking or from being masked, there are studies out there showing that masking is very unhealthy because you're breathing your own waste all day, your own carbon dioxide. It's not good for you. It can cause all sorts of issues. We're seeing lots of bacterial infections in the mouth and upper respiratory tract. I mean, it causes all sorts of issues. So you could actually say, use that same body as a temple of the Holy Spirit argument to request an exemption from masking, basically saying this is unhealthy. And the masks don't do anything either. So you can cite those scientific studies. I don't have that in my forms, but if you want to make that argument, it's kind of a harder one to get out of. Like if the employer really puts their foot down and says, we'll let you out of the shot, out of the jab, but you do have to wear a mask. Really, the only way to fight that would be to sue them and then hire an expensive medical expert to testify for you on that. And that's just, most people are not in a situation where they can do that, but still request it. And then if something, at least you're preserving your rights for that. Now, testing, the employer can likely legally have you pay for the tests yourself, because if they're paying for it, they could say that's more than a de minimis cost on them. So unfortunately, if they are required testing, it's kind of the same thing as masking. You'd have to fight them in court to get out of that one, most likely, and then they'll probably make you pay for it. But one thing, a lot of people have an issue with the swabs because they're treated with ethylene oxide. So if you're getting frequent testing and swabbing yourself with a known carcinogen like ethylene oxide, then that presents a risk of cancer. And so you can kind of use that body as a temple of the Holy Spirit argument again. Say, I need an exemption from the swab tests, and I will I'll do a spit test, because now they have these tests where you can just spit, it doesn't touch your body, and so that should solve the issue. Now, see this a lot. Several, a bunch of my clients are with employers that are trying to charge them more for their group health insurance than other employees. That is blatantly unlawful under Title VII. The Supreme Court has definitively held in several appellate courts that you cannot dole out benefits in violation of Title VII. So you can't discriminate against somebody with regard to, if they're a member of a protected class, and the protected class includes, race, sex, religion, and national origin, and there's other things we discussed earlier. So it does include your religion. So if you're being charged more for your health insurance because you have a religious conviction that prevents you from getting the vaccine, that is discriminatory, and you should apply for an exemption from that policy. If it's denied, then you can file an EEOC charge and you can sue them over it. And I'm probably going to bring a few of those lawsuits because that is going on here in Texas. Okay. So a lot of people ask me, well, what else can I do? What else can I do to resist this? And, this strategy is not without its risks, but I do want to educate you a little on your rights under the National Labor Relations Act. So this is the law that gives you the right to organize with other employees against your employer's policy. Now, and this applies whether your workforce is already unionized or it's not unionized. You still have the right to organize, but just want to advise you, or just let you know, it does not protect if you're a supervisor or you work in agriculture or you're a direct employee of a state or federal government, or if you're not an employee, you're actually an independent contractor. This is not going to protect you. So just be aware of that. But you are, if you are just a rank and file employee, you can engage in what's called protected concerted activities. And it's pretty broadly defined. It's any activity that's really for engaged in for employees' mutual aid or protection. And the specific things that you could do that are protected activities to resist these vaccine mandates would be, you can circulate a petition, and you can actually use your employer's email to do that. You need to do this outside of working hours. So don't do it during regular working hours, wait till after hours if you're going to circulate an email. And basically, if you're looking for other people to organize with you, you just want to simply state, I oppose, this vaccine mandate policy. I'm looking for others to organize with me in opposing it. Contact me and provide your personal contact information so that your fellow employees can contact you, and you all can start maybe a Facebook group or a Telegram channel or something like that, where you can all discuss what you're going to do about it. And then, probably the main benefit of doing something like this would be if you later need to bring a class action lawsuit, then you already know all the other people at your job who are of the same mindset as you. Other things you could do, you could post a flyer in the break room. You could just talk with others about it. You generally want to do that during like lunch breaks, but if somebody's just coming by to chat and that's normal in your workplace, you can mention it, and that's a protected activity. Now, I'm not going to sit here and guarantee you that you're not going to get fired over this, because that is a definite risk, but it is illegal to do that. If they fire you for engaging in any of these protected concerted activities or otherwise discipline you, dock your pay, demote you, something like that, that is interference with your rights, and you can report that to the National Labor Relations Board, and they will conduct an investigation, and they may order your employer to reinstate you. They may otherwise discipline your employer. If they don't do anything about it, they'll usually issue a notice of right to sue, and you can bring your own lawsuit for having your rights violated. But again, do that at your own risk. It's a great way to organize with other employees, and it is protected by law. But I'm not going to sit here and guarantee that your employer is going to follow the law. So what to do if your exemption, and by the way, this has actually worked. I've had a few clients do this. In one situation, it was the employer had the insurance premium surcharge, and this employee circulated an email, posted a flyer, and the company did recognize that was her right to do. And they changed the policy days later. And I also had the healthcare worker I mentioned that got reinstated. She did the same thing right before she got fired. She didn't get fired for circulating an email. She was already going to get fired for not getting the vaccine. But they did end up reinstating her, despite the fact that she had circulated this email, because they knew it was her right to do. So companies generally do, if they have a decent attorney, they know that is lawful and a protected activity. So if you're in a situation where exemption's been denied, that is the best time to get an attorney involved, because if the employer gets a letter from an attorney, they will see you're very serious about this, you know your rights, and they're going to have to suffer the consequences of a lawsuit. And especially, if it's like a slam dunk case where you can work remotely. I've already had a few people reinstated who, we reversed the decision where their exemption was denied, because it is pretty clearly illegal. So I'm going to give you a form. If you can't afford an attorney, or you can't find one in your state to help you to send a demand letter, then I'm going to give you a form that you can do it yourself, and you're really just asserting your rights to the employer and showing them you know the law. You're going to hold them accountable. Now, if they don't reverse the denial of your exemption, they end up terminating you, then to preserve your right to sue, you must exhaust your administrative remedies. And that means you must file a charge of discrimination with either the Equal Opportunity Employment Commission, which is in every single state because it's federal, or your state's labor department. Now, most states, Texas included, has a work sharing agreement with the EEOC. So you can file with your state's labor department. They will share that with the EEOC. So you have actually filed with both agencies if you want to bring a federal lawsuit or a state lawsuit if your state has similar laws to Title VII. You must file that within 300 days. If your state has a process where you can file with the state agency, then you have 300 days from the date you got terminated to file the charge of discrimination. If your state does not have a process where you can file a charge, then you must file with the EEOC within 180 days, so within 6 months. Now, a lot of states, I like in Texas, I encourage my clients to file with the Texas Workforce Commission, because there's a law in Texas that if the TWC does not resolve the charge within 6 months, you automatically have the right to sue. And your state may have a similar law, but again, I'm not licensed in your state, so I can't comment on your state's law. But for sure, if you file with the EEOC within 180 days from getting terminated, then you're good. You're good to go. You're just going to wait for a notice of right to sue to be issued by the EEOC. It's really a stupid process. It has no point to it whatsoever, because the concept is like the EEOC is going to do something, but they never do. 99.9% of the time, they just issue a notice of right to sue, and that gives you the right to bring your own lawsuit. So I already covered this. Once you get the notice of right to sue, you can bring your lawsuit. Already covered all this. What does a lawsuit involve? So once you get that notice of right to sue, you're probably going to want to either, if you've hired an attorney to bring a lawsuit for you, your attorney is probably going to send another demand letter saying, hey, we got the notice of right to sue. We're about to sue you. Are you sure you don't want to settle, reinstate, or, pay severance? And then your attorney will file the lawsuit. And, again, if you're a work remote employee, that's an easy one to win, because you don't have to hire a medical expert to testify. That's probably going to be your biggest cost in this type of lawsuit. And it's hard to find medical experts that will stand up and testify about this in court. But if you can work remotely, that's something that a jury can understand. They don't need an expert to explain it to them. They can understand you're not around other people, so you're not a workplace safety issue, burden, and your employer has already let you work remote. So what's the burden? So that's a fairly easy case to win, in my opinion. Or it should be in theory. But if you're not in that situation, that's going to be a little bit more of an expensive lawsuit. And these lawsuits usually last 1 to 2 years before they go to trial. I know it sucks, because you got to wait. You got to file your charge of discrimination. You got to wait for that to be resolved. That can take 6 months to a year if you're filing with the EEOC. And then you got to wait another, discovery. That's when both parties are sending requests for documents, taking depositions, sending interrogatories, gathering all the evidence. That usually takes about 9 to 12 months. Most lawsuits do not go to trial. Only about 5% of lawsuits go to trial, and most lawsuits will settle towards the end of the discovery phase once all the facts are known. And the damages that you get if you go to trial you get your back pay, which is what you would have earned from the time you got fired to the time of the trial takes place. If you've gotten an alternative job, a replacement job somewhere in that time period, then it'll be the difference between what you're earning at your new job and what you would have earned at your old job. And then, of course, any periods of unemployment, that would be, you get full back pay. And then after trial, you can also get front pay. That's everything that you would have earned after trial into the future, and it's kind of up to the jury to determine how many years that would be. 1 to 2 years is kind of standard for front pay. It's kind of giving you more time to find a job because it may be really hard to find a replacement job. And then you also get mental anguish damages. That's everything you suffered. I know that when I got terminated, I suffered a lot. It blew up my relationship, and I had to sell my house. I lost a lot of friends. It was a very traumatic experience. It was all over the news. So, those are all mental anguish damages that you would get, from a jury. And then you get your attorney's fees paid for. So that's always great. All the hours your attorney put in, that goes into the award. So a lot of banks will take these types of cases on contingency. They will help your lawyer finance it. That may be hard because this is such a politically charged issue. I'm trying to find banks that will work with me. I have one that's I'm kind of talking to. Class action lawsuit. This is a great way if you can't really finance the litigation otherwise, then regardless, you can share the costs if you have other plaintiffs, a whole class of plaintiffs. And these are just all the people that were similarly situated with you, which means you all got fired for the same reason. You work for the same employer, and then a handful of you, or even one or two, could bring the lawsuit. And then once the court says, okay, you have to show evidence there are other individuals that were injured in the same way, and there's too many of them to do all these separate lawsuits. So the court will issue class action certification, and then your lawyer can actually notify everybody else that was fired from your job, and you can all join against the employer in this class action. And it's more efficient and cost effective for both parties. So there's my current card. If you want to take a screenshot and share that. And then let me go ahead and let's see. I'm going to get out of this, and then we'll go through the written materials, and then I'll get to the questions.